There are no, would you raise your right hand, please? You solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
All right. Let's start out this way. Why don't you tell me why you think you're entitled to a personal protection order under the stalking?
It's actually, I'm here because of a shared combined driveway / easement that Mr. Brown is preventing me from using. That's in my deed on 2 properties that I used to own 2. Now I own 1 and my daughter owns the other one. He keeps blocking with giant rocks or trucks or trailers. And we had an addendum that was signed and written in the court next door, preventing either one of us from blocking said driveway / easement. That's why I'm here today.
All right. Well,
it's a state law that it's not, you're not, I'm sorry, I didn't mean to interrupt you.
So, all right. So I did review the file, and I'm not saying that Judge Dimkoff made the wrong decision back then, but typically a personal protection order is not the vehicle to resolve a property dispute. That's a civil suit where the rights are established, and there can be orders that are entered in the civil suit that prevent people from doing things,
yes,
subject to penalties, but typically it's not a personal protection order situation. So beyond blocking the easement, can you tell me anything else that would warrant issuing this personal protection order?
Well, just when I can't access the driveway, so it's not like we're getting face to face or anything like that. It's just that my daughter's going to have school age children, elementary school age kids that will be needing to use that. That's where the bus picks the kids up for school. I rarely use the driveway, but it's still in my deed and within my rights to use said driveway to go to my mailbox and check my mail. I do have an easement off of my property, but that's because I'm landlocked. And the judge had, I asked the judge to write in an addendum that to prevent either one of us from blocking the driveway. And he did so right there, right then. And the paperwork is here. I have a copy of it if you need it.
I've seen it.
Okay. Oh, I'm sorry.
My only point is that typically that's not a problem that's addressed with a personal protection order. So that's why I was asking if there's any other facts that you want the court to, and I'm not saying it's right, that assuming that everything you've alleged in your paperwork is true and accurate. I'm not saying blocking the easement's right, or that he has any right to do that, or if it's a good neighborly thing to do. I'm just saying that that's not a problem that's usually addressed by a personal protection. So is there any other thing that you can point to that would justify granting you?
Said the only way I could see this, him removing the giant boulders in the driveway and prevent him from blocking it, was to come through the same process that I did before. Unfortunately, I'm on Social Security. I'm 65. I do have some health issues. If an ambulance was to need, or a fire truck, God forbid, was to need to come back to my property, they're not going to make it through that way. And if they have to drive all the way around to come to my easement, by then my house could be burned down or I could be dead. And again, I'm going to be having a 4 and a 10-year-old kid's going to be living on the property, as well as my daughter who's with me today and her husband. And my son's eventually going to have a piece of property out there and use that driveway as well. I don't want anything to do with him, no trouble from him. I don't give him any trouble. I just want to be able to use my driveway at my discretion. That's in the state law.
All right. Mr. Brown, what do you have to say?
State law says you have to have a well and a septic to be living on property. No campers are allowed, only during seasonal, March through October. He's been there for 17 years and has no running water, no septic. Here's a whole, you want to talk about harassment. This is all harassment.
That's from years ago.
One at a time.
And I got proof that I've only blocked the driveway with my blocks from August, the 3rd weekend of August of last year up till today. I got pictures of him have his blocked off for over 14 years, week after week after week. So if he wants to sit here and say that I'm blocking the driveway, he's lying in court right now.
So just like I indicated,
Oh,
Mr. Hey, sing. When I'm talking,
Yeah.
you guys don't.
Yep.
Very simple. So just like I told him, the vehicle to address this access issue is not through a personal protection order. The way to address your concerns as to whether somebody can live there and stuff like that is not through blocking it, not through blocking this easement or doing whatever you did. It's to file a complaint with the township. If it's a zoning violation, it's a zoning violation. That's for them to determine, not you. Right?
Yeah. Sir, I've had the zoning administrator out to my home, and they also were trying to go to Mr. Brown's on 2 separate occasions, and they were going to try a 3rd time before court today. I don't know whether they made contact with him or not. The gate he's referring to that's blocking him from coming onto my property is well on my property and has nothing to do with the shared combined easement, nothing. Which would be this picture here, shows where the cul-de-sac is and where the shared combined driveway / ends. And my gate is on the other side of that, on my property. And it was there when I bought the property, because he was doing the same thing to the prior neighbor, or his prior neighbor who I bought the property from. And that's why he put the gate up. This is an ongoing thing. He's been blocking the driveway since that court order expired. Pretty much the next day, he had the driveway blocked, and he has been doing so for all this time. I'm
Okay, so
trying to remain calm here.
So, Mr. Arnold, repeat back to me what I've told you about this case so far.
Pardon me, sir?
Repeat back to me what I've told you about the personal protection order and addressing an easement issue.
Repeat back how? I'm not following you, sir.
I've said it 3 times, and it's clear that you're not understanding. So that's why I wanted you to repeat back to me, if you could, so you understood. A personal protection order does not resolve property disputes.
I understand that now, but this was the only avenue I had or knew how to get it into the court, so at least the judge could see it. I was hoping the same judge would see it and say, yeah, I did write this order, and you shouldn't be blocking the driveway, and stop blocking it now and make it in a more permanent capacity, so it can't be done a few years down the road if in fact the protection order was to expire. I'm not afraid of him. Don't feel physically threatened. I just want to go on with my life and be left alone to use my driveway at my discretion.
So I understand that's probably why Judge Dimkoff authorized this personal protection order, is to solve a problem. But the court is going to deny the request for personal protection order. You have not established facts that establish stalking as defined by MCL 750-411H and MCL 750-411I.
Would stalking be considered trying to use that driveway? He comes running out yelling and screaming, or if I'm getting a delivery from somewhere, or a friend is coming over, they try to come through there and he comes out and yells and screams at them, get off the effing property and don't come back. And I've had to reschedule deliveries. Like I said, God forbid something happens medically that an ambulance can't get back to me.
So stalking is defined by 2 or more willful, separate, non-continuous acts of unconsented contact. Unconsented contact means the defendant initiated or continued contact with you without your consent, and includes following or appearing within the site, approaching you in public or private property, appearing at your workplace or home, entering or remaining on property owned, leased, or occupied by you, contacting by telephone, electronic communication, or email, or placing an object or delivering an object to the property owned, leased, or occupied by you. That's step number 1. Step number 2 is it has to have the effect of having the person cause emotional distress. Emotional distress
I'm definitely experiencing that, sir.
Well, you just told me you weren't. You just told me you were not afraid of them.
Emotionally, yes, I thought.
I'm talking, you're not.
I'm sorry.
Trying to explain this to you. You want to keep on interrupting me?
No, sir.
You've got to vote. Last chance. Emotional distress is also defined as someone that something that could, although does not necessarily cause someone to have to seek mental health. And you told me you're not afraid of them and all that kind of stuff. So I don't think that your complaint meets requirements of that thing either. So, like I said, it's not for this court under this statute, this sort of application, to decide what the property rights are between two individuals. That is through a action to quiet title, or there's a whole different things that can happen in a civil case in the circuit court division where the court has equitable powers to sort that thing out. But this is not the way it's brought before the court to decide those issues. So if you're looking for to prohibit him from doing the things that you're saying he's doing, and a court determines that what you're alleging, that you have the right to do it and all this sort of thing, if you would prove that by preponderance evidence, then the court could enter a restraining order, not a personal protection order, a restraining order prohibiting him from doing that. Likewise, if you're doing things that are against the easement, there could be a restraining order that way as well. If the township thinks that you're violating some part of their ordinance, they can bring a lawsuit against you for nuisance. Okay? So, but a personal protection order does not address all these issues. It has to be a different sort of case. And again, you can nod your head, you can agree, but I'm not saying what you're allegedly doing by blocking this, that you're in the right. If he brought those allegations to me in the proper format, he very well may win. I very well may enter an injunction prohibiting you from doing those things. But like I said, this is not the venue to do it. So for those reasons, the request for personal protection order is denied. That's all.